10 real estate questions about the laws of agency. Now, I hate this topic, but it is an important one to know. All right, let's dive into these questions. Question number one: when an agent does not disclose that they are representing the seller in an ad, the agent may be guilty of which of the following? A, permissible advertising. B, deceptive advertising. C, blind advertising. D, false advertising. The answer is C, blind advertising. Now, no, that is not that you are advertising to blind people. Blind advertising just means that there's non-disclosure by an agent in an ad. Don't get caught doing this because other agents might try and get you fined. Question number two: while at an open house, the listing agent encounters an unrepresented buyer. The agent is asked by the buyer to prepare an offer to purchase. At the meeting to prepare the offer, the agent tells the buyer, "I'm sure I can get the seller to agree to this price and get the financing you need." What has the listing agent just done? A, being a good fiduciary to the client. B, may have created an implied agency. C, has done nothing inappropriate. D, made the seller very happy. The correct answer here is B, may have created an implied agency. Agents must be very careful about what they say to customers. If an agent appears to be the agent of the buyer as well as the seller, they may become a dual agent. Now, keep in mind, in some states, dual agency is legal. In some states, it's a no-no. So understand the laws of your state. Question number three: an agency disclosure is necessary in order to A, let the client know that the agent represents him. B, let the buyer know that the agent represents the broker. C, let the seller know that the agent represents the broker. D, let the customer know that the agent represents him. Correct answer here: A, let the client know that the agent represents him. The agency disclosure form lets a client know who represents them. A customer is not represented by anyone. The agency disclosure does not discuss the relationship between the broker and the sales agent, but discloses the relationship of the broker/brokerage to the seller rather than the buyer. Question number four: Jake lists a property. Jake finds a buyer. Is Jake allowed to write an offer as a buyer's representative? A, no, an agent cannot collect both commissions. B, yes, as long as both parties agree to it in writing. C, yes, if it is specifically written in the offer. D, no, it's against federal trade laws. Correct answer here is B, yes, as long as both parties agree to it in writing. Now, this one is specific to California because in California, dual agency is allowed. In some states, it is not allowed. So make sure you know the specific laws of your state. Question number five: while a listing agent is showing some rental property, it becomes clear that the buyers are about to disclose a confidentiality. They recently won a large settlement in a personal injury case and have unlimited funds to spend on the property. The agent, A, is a dual agent, so it's okay if the buyers tell the agent this info. B, owes no duty to disclose to the buyers any relationship between the agent and the seller. C, is a buyer's agent and will keep the buyer's confidentiality. D, should tell the buyers, before showing any property, not to disclose any confidentiality. Correct answer here is D, should tell the buyers, before showing any property, not to disclose any confidentiality. And here's why. As the buyers are about to tell the sales agent a confidentiality, the agent should tell the buyers before any home is shown that the agent represents the seller and that all information disclosed to the agent will be told to the seller. And in this question specifically, the agent is the listing agent and is not the dual agent, so they do not represent the buyer. Simply showing a buyer a house does not make one an agent of the buyer. So we've gone through 5 questions. If you like these questions and you want more of them, I highly recommend buying a test bank of questions for yourself, a exam prep. So I've actually shared an affiliate link to Calibri. They are the education provider that I've used for all of my licenses. Obviously, if you want to pass the exam on the first try, you want to have the best study prep. Many viewers on my channel have taken this advice and passed on their first try. I want to see you succeed and pass on your first try. Let's get back into the questions. Question number 6. A sales agent is selling their own personal property, the condition of which they misrepresent. The agent is sued and raises the defense that they were not acting as an agent in this sale, but rather were selling their own property personally. The probable outcome of the case is A, the sales agent will win. B, the broker will be liable. C, the sales agent will be held liable. D, the case will be dismissed for no cause of action. Correct answer here is C, sales agent will be held liable. Real estate agents are subject to the rules of professional ethics 24/7, 365. So whether you're selling a property for someone else or you're selling your own property, you as an agent are not going to be relieved of these professional ethics duties. Question number 7, a principal dies. The agent is not aware that the principal has passed away and continues to act on the behalf of the principal several days past the principal's death. Which statement is true? A, the agency relationship has been renounced by the agent. B, any representations or contracts entered into by the agent on behalf of the principal are binding upon the principal and or the principal's estate. C, the agency relationship has been revoked by the agent. D, any contracts or representations made by the agent are void since the principal has already died. Correct answer here is B. Any representations or contracts entered into by the agent on behalf of the principal are binding upon the principal and or the principal's estate. In general, an agency relationship is terminated only if the agent actually knows of the seller's death. Question number 8. An attorney, in fact, is best described as A, fiduciary to his principal. B, an attorney at law. C, a power of attorney. D, a principal. Correct answer here is A, a fiduciary to his principal. And here's why. So an attorney, in fact, receives authority under a power of attorney and need not be an attorney at law. An attorney, in fact, is an agent for the principal and thus owes the principal all fiduciary duties. If you don't know what fiduciary duty means, that's cool. It just means that the person representing someone else needs to look out for that other person's financial interests. Question number 9. The death of the broker or principal, incapacity, insanity, or bankruptcy of the principal are all ways agency can be terminated by A, full performance. B, expiration of its term. C, operation of law. D, acts of the parties. Correct answer, C, operation of law. So in the event of a death, incapacity, insanity, or bankruptcy, the agency relationship automatically ends by operation of law. This means the termination occurs legally without requiring any action from either party. Question number 10. An agency relationship should be created by which of the following methods? A, implication. B, expressed written agreement. C, estoppel. D, ratification. Correct answer here is B, expressed written agreement. So if you just understand what all of these terms mean, you're going to be able to answer this question easily. So estoppel refers to apparent agency, which occurs when someone allows another to act as their agent without actual authority. Ratification happens when an agent's act is accepted after it's already been performed. And implication can establish an agency relationship through conduct, but it's not the preferred or formal method. So that leaves us with expressed written agreement. So because I care about you and I want to see you pass your exam on the first try, I'm giving you a bonus question. Question number 11. The best description of principal is A, an owner of real estate. B, a customer. C, a landlord. D, one who employs a broker to represent their interest in matters of real estate. Correct answer, D, one who employs a broker to represent their interest in matters of real estate. Once again, if you just know these definitions, these questions are super easy. So when you're studying, go through those chapter summaries at the end, make sure you know your definitions, and these questions will be a slam dunk for you. If you enjoyed studying with this video, go ahead and subscribe for more of these videos. You can also drop a comment for the types of questions that you want videos on. As always, thanks for watching my videos, and I hope you crush your real estate exam on the first try.